morning, everyone. Today, we are present here for the complaint made by Ajwa for Food Industry Company of Egypt. Before we proceed, allow me to briefly introduce myself. I am Anis Norina binti Abdullah, accredited by Malaysia Arbitration and Mediation Tribunal as one of its arbitrator. As agreed by Arbitrator Tribunal, I will act as the chairman of this arbitral proceeding. So I ask the claimants' counsel and respondents' counsel to introduce yourself. Claimants' counsel first.
My name is Adin Sofia and I'm presenting the Azure Food and Industries.
I am Nur Sakina. I'm representing Pacific Interlink Sdn Bhd as the respondent.
Thank you to both counsel. So before we proceed, I would like to stress the impartiality and independence of this arbitrational tribunal. We have already stated in our disclosure report, which I believe the parties have already furnished with our background, my personal qualification, financial and other personal interests, which I believe will not in any way affect our impartiality, and that we don't have any financial, fiduciary or other interests in the controversy or case to be decided or in the result of the proceeding, or has any personal bias which might prejudice the right of any party to a fair and impartial award. So, may I ask if any of the party and counsel to this matter know of any potential conflicts between the arbitrator and any party or counsel in the matter?
No.
No. Okay. For the information of the parties, arbitration is a system of private justice to settle a given dispute outside the jurisdiction of state courts through persons chosen by the parties to adjudicate that dispute. To begin with, the following are the general rules governing the procedure of the arbitration in the case. In conducting the proceedings, the parties are free to agree on the procedure to be followed by the arbitral tribunal as stated in section 21 subsection 1 of the Arbitration Act 2005. Section 25 subsection 1 of the Arbitration Act 2005 provides that within the period of time agreed by the parties, or failing such agreement as determined by the arbitral tribunal, the claimant shall state A. the facts supporting his claim, B. the points at issue, and C. the relief or remedy sought. In the other hand, by virtue of Section 25, subsection 2 of the Arbitration Act 2005, mentioned that the respondent shall state his defence in respect of the particulars set out above, unless the party have otherwise agreed to the required elements of such statements. The parties may submit with their statements any document the party consider relevant, or add a reference to the documents or other evidence that the parties may submit. Section 25, subsection 3 of the Arbitration Act 2005 stated that unless otherwise agreed by the parties, either party may amend or supplement the claim or defend during the course of the arbitral proceedings, unless the arbitral tribunal considers it inappropriate to allow such amendment having regard to delay in making it. So now, without further delay, let's start with the facts by claimant's counsel.
For your information, Our side had initiated the arbitration proceedings against the other party, alleging that the other party had failed to take delivery of palm oil products which the other party had ordered from us pursuant to written contracts which contained arbitration clauses. And it is undisputed that both parties had always dealt in an informal basis. In addition to that, the other party did not dispute purchasing the products from us and admitted that agreements were concluded through telephone conversation and email exchanges prior to any informal documentation being exchanged for confirmation.
I am the lawyer presenting respondent, Ajwa Food and Industries. So I would like to continue arbitration by explaining the position on behalf of the respondent. Firstly, the respondent did not deny that there was an agreement to purchase the products from the respondent through telephone and email exchanges. Firstly, that the claimant and the respondent have had a long trading relationship over 20 years. So there was a past practice for the respondent and appellant to refer their dispute to arbitration via fuswa operam. So the next contention on behalf of the respondent is that contract between respondent and the claimant is only an oral contract, either through telephone conversation and email exchanges. Uh, However, this is not including standard terms and conditions. So, firstly, the respondent would like to submit the first evidence by referring to Ms. Omnia Talaat to email messages to support the contention of the respondent. Firstly, email dated 5 May 2008 and 7 September 2008, both from her to the claimant's representative, Sir Josh Buttress. So from this, it is noted that there is absolutely no reference to the alleged oral contract at all in any of the said email. Therefore, the respondent believes that oral contract does not form. This is due to the fact that the standard and terms and condition from the email does not clearly stated about the oral contract. So there is absolutely no in reference. There is no oral contract. So this not on behalf of the respondent to commit for long trading.
After considering the pleadings and hearing testimonies by both counsels and taking into account both oral submissions of the counsels, made the ruling on the preliminary issue of jurisdiction in that the tribunal finds there are contract in writing between the claimant and the respondent, incorporating the standard terms and conditions of sale of the claimants by reference to arbitration. The tribunal has the necessary jurisdiction to deal with the matter as there was clearly an express agreement to refer and hear their dispute to an arbitration. Therefore, in the result, I award damages for a sum of USD 1,374,200 and also USD 2,261,100 in favor of the respondent.
This is Agnes Sophia presenting the appellant on the ground that put forward by the appellant in applying to set aside or amend both the Arbitration Tribunal award was that the said Arbitration Tribunal has no jurisdiction to hear the arbitration case in question as there was no agreement between parties to arbitrate their dispute. Here, first question before but whether for the purpose of Section 9, Subsection 5 of the Arbitration Act 2005, the agreement in writing where a reference is said to be made to a document containing an arbitration clause must satisfy the conditions of an agreement in writing as set out in Section 9, Subsection 4 of the Arbitration Act 2005. At the same time, the appellant had also filed an appeal of the same arbitration awards to the Palm Oil Refiner Association Malaysia and Arbitration Appeal Board, and the appeal pending. On this issue, on clause 31, it is submitted that contention of the appellant is that the said clause 31 was never incorporated and it never had sight of the said terms and conditions. It is undisputed that parties had always dealt on an informal basis. The appellant did not dispute purchased products from the respondent. The appellant admitted that the agreement were concluded through telephone conversation and email exchanges prior to any documentation being exchanged for confirmation. Therefore, the appellant submit that they alleged that the sale contract which were relied by the respondent did not contain any specific dispute or resolution clause and in most cases were unsigned. As for the sale terms and conditions, this was a separate document produced during the arbitration which the appellant contended it had never seen nor agreed to it. By quoting in the case of Bauer Sendi Prihat and Dawu Corporation, whereby in this case the court of appeal held that to begin with, it is important to recognize that the foundation of an arbitrator's jurisdiction is the agreement entered in the disputant. Absent such agreement, there is no jurisdiction. By referring to the Article 7 subsection 2 of the Unicentral Model Law on International Commercial Arbitration, 1985 in its original form. This also can be found in Section 9 of the Arbitration Act, where it is expressly stated that in this Act, arbitration agreements mean an agreement by the parties to submit to arbitration all of certain disputes which have arisen or which may arise between them in respect of a defined legal relationship, whether contractual or not. It is important to highlight that an arbitration agreement is in a writing where it is contained in a document signed by the an exchange of letters, facsimiles, or other means of communication which provide a record of the agreement, or an exchange of statement of claim and defense in which the existence of an agreement is alleged by one party and not denied by the other. Based on the above provision of Section 9 of the Act, it was contended for the appellant that the arbitral tribunal, in determining its own jurisdiction, had to ask itself whether the respondent had discharged the burden of establishing existence of an act. The respondent and the appellant on the manner in which the dispute between them should be adjudicated. Believe that the sale terms and condition relied by the respondent is a separate document from the sales contract. It was also submitted that there is no evidence that the sales and term condition is a genuine or even contemporaneous document used in transaction between the parties. Therefore, we would like to submit that there is no reference to the sales and terms condition any document evident before the arbitral tribunal, which signified that the appellant had seen and agreed to these particular terms in each of the transaction in question. As a result, believe that the sales term condition was not attached to the sales contract and it was not sent to the appellant or otherwise referred to in a specific ambiguous manner. As such, no notice of the sales and terms condition can be attributed to the appellant. It follows that the sales and terms condition cannot be said to have incorporated into the agreement between the parties by reference such as to make it part of the agreement between parties. We also submit that the sufficiency of word that purport to incorporate arbitration agreement by reference on this point, the clear language is required to ask the jurisdiction of the court. The statutory requirement for an arbitration to be in writing is the clear indication that the party is not to be regarded as relinquishing access to the court lightly. An arbitration clause is an independent and self-contained contract and is not to be regarded as merely another term in main contract, which can be incorporated by reference to that main contract. It is therefore submitted for the appellant that the arbitral tribunal should have but failed to determine whether there was a clear enough intention from the word used in the sales contract as a measure of construction that the appellant agreed to from the word used in a sale contract as a matter of construction. If he had applied the correct analysis, the arbitral tribunal would not have found clear intention of the appellant to refer dispute to the palm oil arbitrations.
It is to be noted that the respondent and the appellant have known and dealt with each other in commercial transactions for a considerable period of time, but more regularly during the last 5 years before the present dispute, where the appellant had regularly purchased from the respondent palm oil products to meet the raw material requirements for its factory. And respondent also submitted and it proven through the evidence adduced before the Palm Oil Refiners Association of Malaysia Tribunal that it conducts its business with its buyers, including the appellant, in accordance with the standard terms and conditions of sale. The sale prices of the respondent supply contracts are determined at the option of the buyer through one of two pricing methods as set out in Clause 6 of the standard terms and conditions of sale, which the appellant had full knowledge through the course of previous dealings. And last but not least, respondent had shown the evidence before the arbitration tribunal that it had issued and faxed to the appellant the said sales contract.
On the above considerations, we find that the appellant's ground of appeals to set aside or vary the Forum Arbitration Tribunal award under Section 37 and 42 of the Arbitration Act 2005 are misconceived both in law and fact. We therefore dismiss both the appeals with cost of 10,000 ringgit to the respondent for both appeals. We affirm the findings and decision of the learned High Court judge in both cases. We also make an order that deposits in respect of both appeals be paid to the respondent on account of fixed costs.